Hi, everyone. Thank you for joining us. We hope you're staying safe and in good spirits in these testing times. Keeping the current pandemic situation in mind, we thought it would be good to run a webinar covering the impact of COVID-19 on labor and data protection matters. I have with me my colleague Ala Mumtaz, who would be covering the key considerations from employment law's point of view, and I will run you through some of the key data protection concerns. Please note, all attendees are going to be on mute, and you can send us your questions in the question box, which we will take up at the end of the session. Over to you, Ala.
Thank you, Krishna. Good morning, everyone. Hope everyone is staying safe. As Krishna just mentioned, we assume that everyone is full aware of the recent updates and the news that has been roaming around the country for the past several weeks. And because there are so many of them in so many different sectors, government decisions, ministerial decisions, free zones, everything, we thought it would be important to just have this webinar to recap and shed some light on the recent ministerial resolutions impacting the private sector from an employer's perspective. And so we will go through the presentation, starting with the immigration and the travel restrictions updates. Then we would go to the health and safety measures and the quarantine, and finally with the recent ministerial resolutions that were issued by the end of March. And then I will hand over to my colleague Krishna, who would be talking about the data privacy. And finally, there would be a Q&A session that people could post their questions, and we would read them and answer them to you. Next slide, please. So as we were mentioning, this is the agenda for today. We will be starting with the immigration, health and cost cutting measures, data privacy, and then the Q&As. Next slide, please. So from the immigration and travel restrictions, as a general update, then the UAE has now effectively closed its borders until further notice, with the following restrictions now in place. UAE national citizens have been banned from traveling overseas, and those currently overseas have been advised to return back to the UAE. In terms of UAE residents, those who are holding a residency visa, who are currently outside of the UAE, will not be able to enter the UAE again. This was initially for a period of 2 weeks, commencing from the 19th of March, but then it was extended for a further period of 2 weeks on the 2nd of April. There is a very important note in this section. We need to highlight that the employer should notify their employees who are currently outside to register their details on a system called Tawajudi. This is a service portal provided by the Ministry of Foreign Affairs and International Cooperation. If you could log into the ministry's website or just type in Tawajudi on Google, you will be able to find this portal, which the employees should register their details. This portal would facilitate the process of the communication between those residents outside of the UAE and the ministry in case of emergencies or crises that they're having inside the UAE, so they can facilitate and coordinate the return back to the UAE. So that's for UAE nationals and UAE residents outside of the UAE. In terms of any type of visa issuance, applications, whether it's a mission visa, a visit visa, visa on arrival, all of those has been suspended until further notice. This has taken effect from the 17th of March, and those entry visas issued prior to the 17th are no longer valid. A very important question arises from here. This is all in relation to the visa perspective. Now, in terms of the work permit from the Ministry of Human Resources, so the ministry has suspended the issuance of any new work permits for individuals currently located outside of the country. This means, from a recruitment perspective, for all employers who want to hire new individuals or new positions, they should consider this fact and make sure that whoever they are interviewing, their candidate, is located inside the UAE and preferably registered with the Ministry of Human Resources. So we've seen people moving from one position to another, from an onshore to onshore, or from onshore to offshore. But the most important factor is he's inside the UAE. Any individual who's outside the UAE, the Ministry of Human Resources will not issue him a work permit. In terms of the suspension of passenger flights in and out of the country with effect from midnight Wednesday the 25th, although Emirates and Etihad, as people can see now, are allowing limited repatriation flights to a handful of countries, and for specific reasons, we consider them emergency reasons that the airlines would consider. So for UAE residency visa holders that are trapped outside the UAE, whether they were following personal or business travel, what does this mean for the employer? Should we continue paying them salary? Should we put them on unpaid leave? This also is a very important point that we get asked a lot. So for employees who are trapped in another country due to this country's specific lockdown and are able to continue to work, so they can work remotely from wherever they are, or they can work at an office in the current country of location, if applicable for the organization, they should continue to be paid their normal salary in a very normal way. For those employees who cannot work from home or remote working is not possible for them, employers can adapt such measures as special leaves on full pay, or they could ask them to utilize their untaken annual leave balance. They can put them on unpaid leave, subject that they get a written consent from the employee. And obviously, this differs from a case-to-case basis. Again, as mentioned previously, for people who are trapped outside the UAE, whether for personal or business travel reasons, they should also be advised to register their details on the Ministry of Foreign Affairs portal, Tawajudi, so it can facilitate their communication, because some of the employees who are trapped outside are not aware of this, so it could be considered the employer's sort of moral obligation to inform them that there is a service portal for them to communicate with to coordinate their eventual return to the UAE. Next slide, please. Health and safety. As a general remark, the key for employers when dealing with the disruption caused by COVID-19 is to enter a simple, friendly dialogue with employees as to how to treat this very unique situation. In making those arrangements, employers should be wary of adopting an approach which might adversely affect staff morale. A fair and consistent approach should be adopted, and a case-by-case approach also might be appropriate in certain circumstances. In general, employers have a legal duty to protect the health and safety of their employees and to provide a safe place to work. Aside from the legal duties, there is a strong moral imperative for employers to ensure that their staff feel safe and secure at work. See, these circumstances may not be applicable at the moment, considering the 24/7 lockdown that we're now facing. But the reason that we're still highlighting those safety measures that should be included or should be applied by the employer or by the companies is that because when the lockdown is lifted, or when those restrictions are lifted, we considered that the government is not going to lift it all at once and open the gates wide open. It will only be a gradual lifting of those restrictions. So we consider that you would still need to apply those safety measures even after the crisis calm down, and hopefully within the next coming few weeks. So the companies should also adapt precautionary measures to protect the general well-being, health and safety of all employees, such as ensuring the hand sanitizers, tissues are well stocked and available in all workplace locations. The company should also ensure policies are effectively and transparently communicated to all employees on a periodic basis. Now, for employees who are held on quarantine, so these are the quarantine scenarios that we have been receiving from our clients. There are diverse quarantine business-specific scenarios stemming out of the COVID-19 crisis, and each comes with a slightly different implication. In the first instance, where an employee is diagnosed with COVID-19 or is exhibiting symptoms of COVID-19 or is just sick from non-work related reasons or non-COVID-19, he or she should be paid their sick leave for the period of their absence in accordance with the standard statutory sick pay rules, which are mentioned under the UAE labor law, or if generous, if the company is, if more generous, if the company has the capacity to do so. As an employer, you have a legal obligation to notify the health authority in the emirate the company is operating in the event that you suspect an employee or has COVID-19 or is actually suffering from COVID-19. And any failure to do so risks the imposition of penalties to be enforced by the authorities. The other scenario is for employees who are not diagnosed with COVID-19 or otherwise sick, but due to the government mandated quarantine are compulsorily required to self-quarantine for 14 days. The approach payment would depend upon whether they are able to feasibly work from home or not. Again, takes us back to what we were discussing in the immigration restrictions. Generally, if the employee is able to work during the quarantine periods, paying the employee their normal salary would be the normal course that is recommended, the business as usual approach. But if by nature of their position or their role in the company, they cannot work from home, alternative measures should be considered, again, such as whether it's a special leave that is paid, asking the employee to utilize their annual leave during this period. You could also put in a sick leave utilization or ultimately an unpaid leave if the employee does not have any annual leave balance. Next slide, please. At the end of March of 2020, the ministry issued a series of resolutions to help facilitate the employers-employee relationship in terms of how to take this forward and how to face the COVID-19 crisis and especially the private sector that has been affected by the measures taken by the government. So in terms of the remote working, the ministry issued the ministerial resolution number 281 of 2020, which is a form of a guide to regulate the remote working in the private sectors and set out the obligations of both the employer and the employee in terms of remote working. And we could highlight the main obligations of the employer by providing the necessary technical tools for the employee to perform their work remotely, to put in place the mechanism and the standards of competence and productivity, to determine the timeframes for tasks assigned to each worker, ensure the availability of the safe technological environment to perform the remote work, follow remote workers to ensure their observation, and obviously to facilitate the communication of remote workers with their colleagues to perform the task and access information or the platforms necessary for work performance. In terms of the employee's obligation, they're pretty much simple as the employee should report to work whenever requested, to perform the task within the specific time frame as requested by the employer, be reachable on his cell phone or emails, and utilize the means of communication to ensure the continuous communication depending on the business need, provide his employer with proof of accomplishing the work or the task that has been assigned to him. These are pretty much the obligations of the employer and the employee in the resolution number 281 to guide employers in the private sector. There are some establishments that are exempted from the remote working and are exempted from this specific resolution, and we'll highlight them for you. And these are also going to be available after the webinar. These exempted establishments, we have in the financial sector, this include banks and exchange outlets, food industries, which include the manufacture and distribution of food, hospitality sectors, which include hotels, restaurants, and catering companies, companies and factors in the production of sterilization and cleaning material, medical equipment, and cleaning companies. In terms of the healthcare sector, this includes hospital, pharmacies, pharmaceutical factories, clinics, and all other medical services or providers. The infrastructure projects are also exempted. This includes road and bridge works, water services, sanitation resources, electricity, building and construction sites, contracting and construction firms, engineering consultants, catering companies, including associations and stores selling food commodities. Finally, energy companies, which include oil companies, oil refineries, power plants, gas station, and the sale of distribution of fuel. Next slide, please. The resolution that was issued on the 26th of March is resolution number 279, which was a very important resolution because it gave the employer some flexibility or shed some light on how to proceed with whether on how to face the COVID-19 crisis and how to regulate the relationship between the employer and the employee. The resolution is effective from 26th of March, and it affects the private sector companies and only non-UAE national. So the measures that are introduced by this resolution given to the employer can be outlined in the following. So we have the very first thing is obviously working from home. So the resolution gives the employer the right to implement a work from home system. And again, following this resolution, which is number 279, was introduced the other resolution 281, which offered the guidance and the regulation of the remote working. The second measure is leave with pay. So the resolution confirms the employer's entitlements to ask employees to utilize their annual leave in accordance with the UAE labor law. So as we mentioned earlier, the UAE labor law gives the employer the entitlement to force employees to utilize their annual leave balance. But the resolution kind of confirms this position. It does say that the employer should take the employee's consent, but considering that the law would supersede any kind of resolution, we would still consider that the employer has the right to put the employee on the leave with pay without having the written consent. The third measure is unpaid leave. Subject that the employer obtains written consent of the employee, the resolution allows the employer to place employees on an unpaid leave. This can be considered one of the newly introduced measures taken by the ministry, since the concept of unpaid leave was not specified in the UAE labor law. The fourth measure is a temporary salary reduction, which obviously must be taken with the consent of the employee. And when an employer wants to reduce the salaries of the employee for a temporary period, a specific form that is attached to the ministerial resolution must be signed and kept in the employee's file with the employer, which means that the employer does not have to submit this form to the ministry or to the WPS, but must have it signed and must have the physical copy in their office to be furnished upon the request of the ministry. The reason for this, we've learned from the ministry that some employers are taking this for granted and are just reducing salaries without having the employees sign the specific form. And when employees report this unfair act from the employer, only then would the ministry contact the employer and ask them for the written form, for the signed written form. The fifth measure is the permanent salary reduction. And again, it has to be signed by the employee, but this has to be a newly or an amended contract that has to be signed and submitted to the ministry. So unlike the temporary reduction, you need to sign this with the employee, amend the contract, and submit it to the ministry so it can submit it to the WPS and make the required changes. Finally, and we think this is one of the most important measures that were introduced in the resolution, is redundancy. And the reason we believe this is because the concept of redundancy was not recognized by the UAE labor law or even by the local courts. So the resolution provides procedural guidance to protect employees in circumstances where the employer identifies a surplus of their non-UAE national workers. So the resolution provides that the employer must continue to provide the outgoing employees housing and all of their entitlements except for their basic salary until the earlier of the individual exiting the UAE or obtaining the relevant or obtaining alternative employment or sponsorship within the UAE, or if the resolution as a whole is revoked or repealed. So it's the provision is not very clear in terms of housing and all other entitlements that should be paid by the employer even after the termination. It could be defined as paying the housing allowance or accommodation if the company is providing accommodation, and education allowance, schooling if the company is providing, transportation allowance, tickets, even if it's not utilized. Simply, the article is not clear. It only states to housing and all of their entitlements except for basic salary. So it could be defined as really every entitlement except for basic, or it could be defined as the basic allowances to housing and transportation allowance until the employee exit the country. This is still yet to be seen. Whenever some employee, either the ministry will issue some guidance in the next coming few weeks, or we'll just wait until an employee files the case, and we'll see what the courts define or interprets this provision. After the termination or the redundancy situation, the employer is required by virtue of the resolution to offer outgoing employees the option of registering details on the ministry portal for job seekers, which the resolution identified as virtual labor market system. It's available on the ministry's website as we speak. uh, these employees can then be rotated and utilized by other establishments seeking to hire candidates within the UAE, given the suspension of foreign recruitment, as we've highlighted in the immigration restrictions. These employees can then be hired and authorized with the work permit, and then the employer's obligation to pay the allowances would cease to exist. The resolution does not specifically provide or talk about arbitrary compensation, arbitrary dismissal compensation in the event of redundancy. However, the recognition of the concept of redundancy itself within the resolution may be an indication in the future that the UAE labor courts, when considering a labor claim filed by an employee who was made redundant during these crises, would work in the employer's favor. And again, all cases are going to be viewed on a case-to-case basis, whether the employer's termination for redundancy was justifiable or it was made for wasn't an arbitrary decision. So these are all the recent updates in terms of the ministerial resolutions. And for people who joined in late, I'll be handing over to my colleague Krishna to talk about the data privacy section. And at the end of the session, we will be having a Q&A session, which you can fill in your questions in the questions tab, and we will read them out loud and answer the questions. Over to you, Krishna.
Thanks, Ala. In this segment, I would like to address what employers should keep in mind while processing the personal data of their employees in the context of COVID-19 situation. As you are aware, UAE does not have a comprehensive data protection legislation or privacy laws similar to other countries. Privacy is a qualified right provided under the UAE Penal Code. Therefore, this right would have to be balanced against other laws. The COVID situation would primarily be covered under the federal law concerning communicable disease prevention. The federal law prescribes a list of communicable diseases and enables the Ministry of Health to take measures to protect public health by requiring information about persons with such communicable diseases. We assume that COVID-19 is added to that list. It is Article 10 of the law which is pertinent in terms of what it allows an employer to do. An employer can exclude a person from workplace where an employer suspects that an employee may have communicable disease. He can also refer the employee for medical examination, which, if positive, requires the employer to report the worker to the health authority. Under this law, there is no general override of the right to confidentiality of health information. Thus, the employer cannot require the employee to answer questions. However, there may be some understanding between the employer and employee in the employment contract or in prior consent forms, which would allow the employer to ask such questions. The Communicable Disease Prevention Law is a federal law concerning public health and will apply in all free zones. We know that amongst the free zones, ADGM and DIFC have their respective data protection regulations. Under both these regimes, health data is classified as sensitive personal data. And one of the legitimate purposes for processing sensitive personal data includes preventive medicine, medical diagnosis, and the provision of care or treatment or management of healthcare services. Keeping the COVID situation in mind, the ADGM Office of Data Protection issued specific FAQs addressing the implications from a data protection point of view. The Office of Data Protection is aware that data controllers may need to share personal data rapidly or collect personal data of visitors to their premises for purposes of contact tracing or other response measures. To that effect, it has clarified that the data protection regulations do not prevent a data controller from processing personal data in case of emergency, provided that the personal data is processed fairly, lawfully, securely, and it is adequate, relevant, and proportionate for the purposes for which it is being processed. The other clarification that was provided by the office was that the data controller should keep employees informed about any cases of COVID-19 in their organization and take the necessary measures to keep employers safe. However, employers should avoid naming the individuals. Further, the Office of Data Protection also clarified that it may be reasonable under the present circumstances to ask an employee or a visitor if they have visited a particular country or are experiencing COVID symptoms. If additional health data is required, employers must ensure that they do not collect any more personal data or sensitive personal data than is necessary. And employers must ensure that any personal data or sensitive personal data that is collected is treated with adequate safeguards as specified under the data protection regulations. The DIFC Data Protection Authority has not issued a similar FAQs, but we assume that they are taking a similar approach. One of the key things to remember for the ADGM and DIFC entities is that the data protection authorities may need to be notified in case of change in the processing activities. Therefore, the data controllers would need to assess if there is a need to update their notifications filed previously with the data protection authorities to reflect the fact that sensitive information, which is now health data, is now a part of their processing activities. This brings us to the end of the webinar. We'd be happy to take any questions. We'd be happy to go through the questions that are out in the question box.
So I think I'll start by taking the very first question we've received. It's a question divided into 3 questions. So the first one is, can the employer cancel the visas of employees who are made redundant while still providing them with the housing and other benefits? Resolution number 279. The answer is yes, the employer can still cancel the visas of employees, obviously, as long as they cancel on the cancellation form and as any other required documentation by the ministry and the immigration department. Once they cancel, the housing and the other benefits are not payable. It's only when the employee is still sponsored by the organization, the obligation of paying all benefits, or as mentioned in the resolution, housing and other benefits except for basic salary, is payable. The second part of the question, if the employer managed to cancel the visa, how long should he continue providing them with medical coverage? The answer is no. The employer only has to provide the medical coverage as long as he is the sponsor. So once the sponsorship is cancelled, the employer has no obligation to provide the medical coverage. And then it would, because once it's cancelled, the employee would be left with 30 days to exit the country. In normal circumstances nowadays, obviously they will not be able to exit, but they agreed on cancelling the visa, probably to seek alternative employment, and not to mention the fact that the immigration department are not imposing penalties for overstaying during this period. The third part of the question, till after the grace period of legally staying in the country. Oh, so it's part of the question. No, once the employer slash sponsor cancels the visa, they are no longer required to provide the medical coverage. Strictly speaking, we would, however, advise, if the policy is already existent, the employer might think of keeping it for the employee until he either exits the country or finds alternative employment. The second question is, can employers ask employees in the UAE to go on forced annual leave during stay-home notification? The answer is yes. Under the UAE labor law, the employer has the right to put the employees on their paid leave and ask them to utilize their annual leave balance as long as the business requires him to do so. It's only the unpaid leave that requires the consent of the employee. But the answer to this question is yes, employers can ask employees to utilize their annual leave balance during the stay home notification. If a company is making employees redundant, does the company have to provide 1 month's notice as is standard, or is it waived and replaced with housing payment until the employees find a new job? So the notice is a contractual and statutory entitlement. So if it's 1 month as per the minimum requirement of the law, or if it's more, if it's 3 months as per the contract, the employer has to honor this obligation, whether if he needs him to work this notice period, he would be working from home or working from the office. He would be paid his full salary, basic plus allowances for the full 3 months or for 1 month, if that's the minimum requirement. So he could ask him to work his notice, pay him his full payment. He could ask him to stay home, take a garden leave, or termination effective immediately, and he would still pay him in lieu of this notice period on the full pay. The article or the resolution talks about the period after the employee finishes his employment with the employer, after he's being made redundant. So the notice period is still considered a part of the employment relationship. On the last day of the notice, that's the last day of the employment relationship between the parties. This is when the employer would have to be paying the housing allowance and the benefits, except for the basic salary. So to summarize, uh, the notice period is separate from the payment of the housing. As long as the employee is still with the company during this notice period, he's going to be paid his full salary. Only after that, after the expiry of the notice period, the employer would pay out the housing allowance and other benefits. If a company contract does not have a breakdown of allowances, what would be considered a fair housing allowance? This is going to be left with the organization to decide. We've talked to the ministry and asked them. The resolution talks about payment of housing allowance or providing accommodation in case of the company providing accommodation. What about employers who offer 100% of the employee's salary as a basic salary? We know a lot of companies that are offering this, and they don't have either a breakdown of the salary, whether any kind of allowances, or they are providing accommodation, and it's only 100%. And the ministry's reply was, we will strictly follow the provisions. You would have to provide the allowance and the benefits as mentioned in the contract. In this situation, we believe that the employer does not have an obligation to be paying a housing allowance. But as it states in the question, what would be considered as a fair housing allowance? We think it would depend on the seniority of the employee. What's the exact address for the government site to register when outside? So it's the Ministry of foreign affairs and international cooperation. Inside, you will find something called Tawajudi portal, or in their e-services, it will be a service called Tawajudi. This is where the employees need to register their details for the communication, or to facilitate the communication between those employees outside, or those individuals outside of the UAE and the ministry inside, to facilitate the return in the event of an emergency or crisis. Obviously, each would be considered on a case-to-case basis. What if an
I,
employee is, Krishna, you were saying?
yes, I was thinking maybe I can take up a few data privacy questions. I
Please.
understand that somebody may have missed something, or maybe I went too fast. So basically, what I was trying to say is that as per the communicable disease prevention law, uh, the employer is allowed the uh, Section 10 of the law grants the employer the right to take such information from the employees and accordingly report this information, send the employer for medical examination, and accordingly report this information if there is a positive suspect to the health authorities. And generally speaking, the federal law on communicable prevention disease does not have like a right to confidentiality. However, therefore the employers cannot force the employee to answer these questions, but this should have been covered in the employment contract or in prior consent forms. With respect to the ADGM, Office of Data Protection, they have issued clarification which says that the data controllers can ask personal data in times of emergency. And the personal data can include information, for example, where where the visitors have what the countries the visitors have gone to previously, or if they are experiencing any symptoms of COVID-19. And while fully understanding that under normal circumstances, these would be termed as personal data, but under the present circumstances, it is seen that it is advisable to ask such questions, making sure that processing of this information is done in by way it is clarified under the data protection regulations, which is that is processed fairly, lawfully, and securely. One of the other questions raised was that whether the healthcare provider is permitted to ask questions to individuals without having their prior consent. I would like to clarify that the healthcare professionals would sending messages or emails or phone texts to individuals would not be considered as direct marketing under these circumstances, and generally also nothing prevents the healthcare professionals from seeking this information, collecting or sharing personal data. Like I said, that personal data sensitive personal data includes health information, and there is a legitimate purpose which is defined under both the regulations under the ADGM as well as the DIFC, which allows processing of this health data for medical diagnosis or medical purposes. Um, yeah, uh, so basically, and one of the other questions that said was whether the email acknowledgement would work as consent under these present circumstances. It would work. It should work.
Should I
Ala,
take
would you
one?
like to go back?
Yeah.
Yeah, sure.
Okay. What if an employee is stuck outside of the UAE and has utilized their annual leave After the annual leave has been exhausted, which leave can be considered salary reduction, unpaid leave? In these circumstances, if the employee can remotely work from the country that he's stuck in, we would suggest a normal pay on a normal basis. If his position or his role does not allow for working from home or working remotely, then it would be up to the company whether they would decide to utilize his sick leave if that's appropriate, a special leave with full pay, an unpaid leave. But again, this was mentioned. It has to be with the consent of the employee. Uh, does this apply for immigration visas and free zones as well? The annexure. No, for the form of the temporary reduction, this would only be applicable for the onshore companies that are registered with the ministry. It depends on each free zone whether they have their own form. Probably not, but we've learned that some free zones have already adapted and accepted the resolution number 279, and that they will implement it. So unless they have their own form, you would only be the employer would only be required to sign an internal document for the salary reduction. Again, just in case the employee files a claim in the future and claims that it was an unlawful reduction of salary without his approval. What if the employee does not give their consent to the unpaid leave, temporary or permanent reduction in salary? Then what measures can be taken? It would be left to the employer to decide, but obviously it would the employer would have to make the employee redundant or would have to terminate his employment. But our advice is the each and every employer before taking the step has to prove and demonstrate that they have tried to gradually take the steps mentioned in the resolution as much as possible, this being the working from home and then utilizing the annual leave, asking him in writing to take the unpaid leave. Obviously, he would reject. Offer him in writing to reduce his salary, he would reject again, and offer him the final measure, which is the permanent reduction. Again, he would reject. But the reason you need to document all of this is upon termination, the employee would probably file a case to claim arbitrary dismissal compensation and that the company failed to follow the resolution. If the company does not have the required evidence to demonstrate that they have done their part, they have followed the resolution, they have been affected by the measures taken by the government to fight the spread of COVID-19, the employee, on the other hand, was not cooperative at all and hence left the company with no other option but to terminate. We believe that there is a very high percentage that the employee's claim would be dismissed by the court. So the small or the summary to the answer of this question is termination. That's the measure that can be taken. But our advice is try to document all the measures taken gradually as per the resolution mentioned. Now we have so many questions of what happens if the employee does not accept or sign the salary reduction, the salary reduction. So I think this covers everyone, and again, several questions regarding the application of the resolution on free zones. So we've learned that the resolution number 279, which relates to the measures taken by the employer, are accepted by the free zones, except for DIFC and ADGM. Article 281, however, that guides the working from home is not accepted by all free zones. So each and every company registered at a specific free zone need to check with the regulator and see whether both resolutions will apply or not. But we've learned that 279 is applicable by all free zones except again for the IFC and ADGM. Temporary reduction is for how long? So how long is the temporary reduction? So in the form that is annexed to the ministerial resolution, it says a start date and an expiry date for the reduction periods. We've communicated it with the ministry to ask them whether there is specific time frame. Could it be 2 years? Could it be 1 year, 6 months, 3 months? And they said it could be for as long as the employer wants. In any circumstances, all of this would be cancelled when the resolution is revoked. So, and you would need to revisit this salary reduction plan, or in case of permanent, and this is why there is a difference between the temporary reduction and the permanent reduction. The permanent reduction, you change the whole contract with the ministry. So the old one is being cancelled and you sign an amended employment contract you submitted, and this becomes the one that governs the relationship between the employer and the employee. The temporary reduction is only the form that is annexed with the ministry, and we suggest the best way to have it is a 3 months period, but there is no guidance from the ministry on a maximum or a minimum period.
And I think there are a couple of questions which says that if there is anything particular to DIFC entities, or if there are any resolutions. I just like to clarify, and so far as the data protection is concerned, the DIFC Data Protection Authority has not come out with anything specific addressing like the ADGM has. In terms of the employment laws, I would leave it with Ala to answer that.
Thank you. So in reference to temporary salary reduction, employee may not have the means to print and sign the document. In such cases, what is the alternative available? Well, they could e-sign it or electronically sign it by any of the applications which have the e-signature. If not, then a simple recognition or a simple acknowledgement from the employee by email, it would be sufficient at this stage. And when the lockdown is lifted, hopefully within the next or after 2 weeks, then the employer could get their official signature on the form. Free zone companies should also submit to the ministry the amended contracts, or this is for onshore. This is quite unclear whether it talks about the permanent reduction or the temporary reduction. So let's talk about both. For the temporary reduction, you don't need to have the form signed for free zone companies. For onshore, yes, you need to have it signed and kept in the employee's file with the employer to be furnished upon the request of the ministry, if so. For the permanent reduction, the ministry, you need to have the amended contract signed and submitted to the ministry. The free zone as well, you need to have it signed and submitted to the authority. And again, I have to highlight this. employers have to check with their relevant authority or regulator on whether they adapt this resolution or not. From the several authorities like the DDA, the DMCC, we know for a fact that they are following the resolution, but you need to double check with the authority.
I think we have time, just about time, to take another 2 questions probably, but we'd be happy to address any questions you may have if you reach out to us by email. Yeah, keeping that in mind, I'll just ask you to
Okay,
address maybe
yeah,
one or
thank
two
you.
questions.
Okay, I'll take some regarding redundancy. I have 3 in a row. So redundancy pay is for how long? Is it up to the notice period or after the notice period? So I think this was covered before. The redundancy pay, and I assume you mean the payment for the housing allowance and other entitlements. If that's what you mean, then it's only applicable after the notice period, not up to the notice period. So as we mentioned, there are it's 2 separate entitlements: the payment as per the ministerial resolution of the housing and other benefits, and there's the notice period. 2 separate items. First, you utilize the notice period, whether it's garden leave or the employee works the notice, or it's immediate termination. You pay up in lieu, and after the expiry of the notice period on the 30th day or the 90th day, depending on the notice period, you then start paying out the other housing and other benefits. Is there payment for redundancy? It's not clear, this question, whether it's talking about arbitrary dismissal compensation or redundancy payment in terms of housing and other benefits, but to cover both, as per the resolution, if an employee is terminated for redundancy reasons after the effective date of this resolution, which is the 26th of March 2020, so any termination that happens after this would be subject to the application of the resolution, and the employer would then have to pay out the housing allowance and the benefits, all other benefits as mentioned in the resolution, except for the basic salary. As for an arbitrary dismissal compensation, there is no obligation from the resolution itself that allows the employee to claim for arbitrary dismissal. The employee would have to file a claim before the local courts and ask for this compensation, and it would be left for the judge to decide whether he believes this is an unfair dismissal or not. We believe that if the employer can prove financial losses or is being or has been affected by the measures taken by the government to stop the spread of COVID-19, and that the employer has also followed the resolution in terms of the measures that was put in place in terms of remote from home, remote working, annual leave, utilization of annual leave, unpaid leave reduction, all of which has been exhausted with the employee or employees, and was left with no other option but to terminate due to the significant losses, we do not consider that the court would award compensation, only if the employer can prove what was previously mentioned. Yes, so I have another question about the gradual approach or the progressive approach as per the resolution. Can you please clarify the progressively approach? Uh, the resolution in Article 2 says that the measures outlined should be taken gradually. So it has to start with remote work, annual leave, unpaid leave, temporary reduction, and permanent reduction. In practice, this is not very practical. So we've seen employers jumping to temporary reduction or jumping to permanent reduction or to unpaid leaves because they've already exhausted the first one, or it's not obvious and it's not quite clear from the resolution whether this is a mandatory requirement or it's a preference for the ministry that the employer proceeds gradually with the steps to try and help or give enough time for the employee to recover as well, to first remote work and then get his full leave balance and get paid, and then start getting unpaid for a period of time.
I think we'll be able to address the rest of the questions if you can reach out to us on our email addresses provided on the slide. Hope the session was helpful, and we look forward for any other queries that you may have.
Thank you for attending. Stay safe.